This is basically a Phillips Jessups of international moot court competition, where these types of a proper bundle format means the n number of cases, n number of statutes are being mentioned there, which actually acts as a part of the compendium. And these are the normal documentation which are actually being focused that when you are approaching for any big national or international moot court competitions, or moreover, you are even focusing upon, even it's not compulsory that the whole bundle has to be there if you're participating in any moot court. One particular document also is more than enough for you. If you guys have ever believed or imagined that what actually is the need of compendium, some or the other way, it's very important to understand that as Dikshita gave a very beautiful briefing in the beginning, that what compendium is all about, why these types of compendiums are being used, and what is the use of this compendium. The very basic fundamental lies into this particular domain. The compendium, nonetheless, only acts as a point of confidence for you, nothing more than that. You have your knowledge with you have your idea with you know the arguments advanced very well, you know the issues that what you are going to speak in front of the judges, you know the law, everything is there with you. So why again to spend a lot of money over this compendium? If some people, if any one of you have till now participated in any moot court competitions, and if you have also prepared these kinds of compendium, I am very much sure that almost 500,000 rupees you have been spending upon the printing of the papers of like the case judgments, as well as spiral binding, right? So these types of things are there, which actually not only motivates the panel, but also helps the whole decor of your team to actually believe that whatever you have drafted till now is something worth it. So coming to the next part, which simply means that when we talk about what is actually compendium, this is a basic thing that I've laid down there. Majorly, it is being described that a compendium serves as a comprehensive compilation of all the sources materials that you have referred in your legal memorandum or memorial, whatever thing you cite upon. Like, and upon that, something that is very important that these types of compendium has to be in a spiral bound format, if often used for purpose, because many a times it's like you usually punch it, right? Or you staple it, right? So these kinds of practice should be actually avoided, very much avoided, right? So moreover, there is one more practice related to compendium. I must say that there are people who actually believe that what they do is they take a printout. For example, if this is the printout of a judgment, so the moment they speak the number of cases, the one of the speakers will stand and they will give it to the judge. Now, because the judge is able to see your cases on a regular note. But I must say, being a judge in more than 50 national plus international moot court, trial advocacy, and other events, if someone is willing to disperse your attention every single moment, it is not in a positive note. The same ideology can be different from for any other person also, no doubt with that. But it is very important to understand that the judge who is sitting there, he or she actually needs to get some peace at the time of hearing your arguments. Moreover, in terms of various stages of, I could say, various tiers of moot court competitions, whether it's a 3-tier, 2-tier, or 1-tier, or even international moot court competitions, some or the other way, we have witnessed that the judges who are there, they need professionalism, a lot of professionalism. So let me tell you, for example, if this is one of the case judgments and we have it in front of us, so normally turning it over and checking it, what is there in this case, what actually you have referred, without making a flag or without marking or highlighting the same, shall be very much difficult for the judge to go through it. For example, if we talk about any type of case being referred to you, right, at that point of time, when we ask you to check what has been referred, I think that will be very much difficult for you even to understand the basic framework that what actually has been referred in your memorial. It might be very easy for the people who say that whatever we have mentioned, it's there already, it's already there in the memorial. But moreover, if you are stating something related to certain facts, you should back it up with some or the other judgments or cases, right? Or if you have any international treaties or conventions or law or any form of statutes or something, at that point of time also, it's very much feasible enough to cite the same. You might have seen that even in terms of in any moot court competitions or any intra competitions also. So the winner or the runner up who are there, or even the person who approaches to the finals and everyone, they actually try to make certain extra effort, if not more than that. So for that particular instance also, the same thing rises that upon the framing of the compendium, that it should be properly flagged up, it should be marked or highlighted to all the pertinent references which is inside the compendium. And trust me, this is nothing more than making it as a type of easy identification for the judge who's actually seeing it or witnessing the same. Right? That's it, not more than that. Next pointer which comes up is preparing of index. Okay, now when we talk about index, image comes to your mind which says that line by line, 1, 2, 3, 4, 5, all the pointers have been mentioned that these are the cases. I don't know previously what you have done, but after this session, I believe that the strategy that I'll tell you to make these things or cover up these things will surely help you out to excel as well as to assure that the judge was sitting there for your moot court competition shall be in a position to understand that there has been a certain hard work being done and adequate hard work being done. See, hard work and smart work, these two concepts are there. People will say that there is one instance where you take all the cases, put all the judgments, number it 1, 2, 3, 4, 5, 6, your index is done. Correct? But there is something more than that. And trust me, right now you are at a position of student. So for you, this practice is okay. For example, if we normally need to speak about that, what actually we need in terms of getting a good compendium, your only state might be just give me a. Yes, I'm really sorry for the inconvenience that you guys have faced. So, coming up to the next point, that was actually focusing upon the index that is aiding as an effort, like effortless, like navigation. Why we are saying effortless navigation is there is one thing from the point of view of a judge, I'm telling you. I don't know whether you might have heard this or not, but it's a practice. Being a judge, I know, that's why I'm telling you. It might also sound you odd. That's why Jyotirmoy sir is saying this thing. The judge who is sitting at the place to judge your moot court competition, they don't want to make any effort at that point of time. They don't want to do. You might have seen if you have participated in any moot court that if this is the memorial, many a times, many. This memorial is like only on the table to showcase, okay, it's so beautiful, cover has been there, first page has been made, index has been made, statement of issues have been made, everything is made. But the judge never opens it. At that point of time also, when you are arguing, you might be thinking the very basic thing that I have given my all my hard work in making this memorial and the judge is not seeing. And simultaneously, the compendium that you have made, and see, the compendium you have made, you have also spent a lot of money onto it. Trust me, in my when I was in college, I participated in BCI. You might be hearing about All India Bar Council moot court competition is there, and it's a very prestigious moot court competition in which 4 rounds, 4 different sets of like a problem is to be there, and in advance you have to make all the memorials. And just imagine if you have to make all the memorials in advance, then automatically you have to make all the memorials compendium also in advance, correct? So a lot of efforts has to be made. So in my semi-final round also, when I was being appearing before the panel, the very same instance happened. Yes, we were good with compendium, but we actually realized one thing. The appreciation was being given by one of the senior advocates of that time, who said that the crafting of index is something that actually makes the judge go through your compendium. So in that particular moot court competition, I actually realized one thing, that don't or ever or never rely upon the memorial that you are carrying, that the judge will go through it. Never do so. In the further slides, I'll help you out that what actually needs to be there in memorial, and sometimes focusing upon the compendium. Okay. So in that particular format, whenever we talk about these types of circumstances, it's very difficult for anyone to go through your memorial. And see, I know you guys make a lot of efforts in making memorial, 36 page, 40 page. In this BCI moot court competition, only 15 pages were given to us. And trust me, 4 issues we have to frame, and the whole thing was of 15 page. The whole memorial needs to be of 15 page, where 7 to 8 pages was of the argumented ones. Now tell me, on a day-to-day basis, you guys actually take these types of explanation of issues, like I believe almost 4 to 5 or to 6. Bhavna, if you don't mind, I would like to take your question at the end, if it's good for you. Bhavna Tikyani, right? Thank you. So personally, at that point of time, it is very difficult for someone who is preparing a lot of cases, and at that point of time, you are not backing up with all the relevant cases, case studies, or judgments in the form of compendium. It's very difficult. And I must tell you one more thing, that whenever we go for a moot court competition, I don't know how many of you have experienced this thing. For example, in your whole memorial, you guys have previously, in beforehand, you have marked that, okay, to prove this particular issue, in 7 minutes, I will, in total in 7 minutes, in 3 minutes, in the first issue, I will take these 2 cases. And I'll only refer these 2 cases. Now you have referred 20 cases, and you are referring only 2 cases now, right? Now, whenever you go and state the very same thing in front of the bench, I can completely assure you there might be a situation that the judge will ask you, okay, these cases are okay. Now tell me what is the facts of this particular case? What has happened in this particular case? And this is something which makes you blank, because you don't know each and every fact of the case, right? Just to tackle these things and to assure that the panel should not be disappointed with your statement of arguments, the line of arguments, you need to get a compendium with you on the very first hand. So if we complete the conceptual framework of compendium, it's nothing more than a systematical, organized, and categorized material in front of the judge. That's it. There are various things called citations, footnote, etc., etc., etc. In compendium, you need only 3 things: judgments to support your arguments, index to strategize the whole compendium, and the cover page to look beautiful. That's it. Now, sometimes you might be even thinking about that, sir, why we should actually spend this much money on compendium? Right? Because I don't know, nowadays the practice might be different, because in our times, whenever we are about to go for appear for any type of competition, we usually think and see the very first thing, what is the prize money of the competition, irrespective whether we are going to reach or not. But we actually see that, okay, 15,000 is the prize money. Okay, we'll distribute 5,000 each. So for the time being, we'll spend 5,000 each. And the reason for this was that we actually focus upon the drafting and printing of the memorial, the drafting and printing of the compendium. Even you might have seen that whenever we submit these kinds of compendium or memorial, a white page is there just to protect that there should be no dust above the cover, right? Then when you are going to each and every pages before statement of issue, you are again having a white transparent page so that the dust should be not there. What is this? This is nothing more than presentation. In law, we only focus upon presentation. There is one in Sanskrit, there is very beautiful line been stated, which says that pehle darshandhari, fir gun vichari. Now, the reason for this particular line is whosoever, me, you, or any other judge who sits to judge your moot court competition, the very First thing is, okay, let's see what the memorial is all about. He'll like, okay, memorial is good. Now let's see what is the compendium is all about. He'll take the compendium, he'll just turn up the pages and just see, oh, so beautifully drafted. That's it. He's very happy. So you have cleared the first stage. Okay. The first stage of your moot court round, before you even speak, you have cleared it. Now the judge is very much confident. Oh, the students are well prepared. It is being witnessed in their memorial, and see what a bulky compendium they are having. Right. So these things are there. I'm not asking you to make any bulky compendium, but this is just I'm stating the fact. So now coming up, what all are the sources that can be a part of a compendium? See, I have written a couple of sources, mostly in these types of any moot court competition, until unless you are going for international moot court competition. Few things that are there that first and foremost is case law. Right? Whatever case that you have submitted in the arguments, you are referring to the same. Related to case law, let me tell you something very important. This is like what I'll say, something that will actually act as a cherry on the cake. That is, whenever we talk about case law and whenever we actually try to find out the case, if you all have like AIR, SCC, EBC, Manupatra access, amazing. You can use it very well. But for example, if you don't have the same, then what will you do? At that point of time, we actually jump into Indian Kanun, we jump into Case Mine, we jump into Lawyers Club India. Various platforms are there because small portion of any case is being mentioned there. I have witnessed the very same thing when I used to judge. Means recently I used to judge that what you do is from others' memorial, you try to copy one particular paragraph. You are able to see, oh my God, in terms of constitutional rights, like in terms of golden triangle stating 14, 19, 21, you are like, okay, here are a bunch of cases. Let me take the whole. So what you do is you copy the whole thing, paste it. Now, one of the scariest thing I'll tell you, one of the scariest. The scariest thing is sometimes these sources which is being drafted, I'm not quoting to everyone, but I'm stating to few. What happens is just to make a bunch of cases, they state any random name. And if any random name is there, you will never find a case. Now, you might have even seen that when we talk about these types of cases, these cases, some or the other way, either the parties gets exchanged, the month or the year gets exchanged, or you might be in a position that this particular thing was given in that particular memorial where it was stating that Narayan Murthy versus state of Tamil Nadu. Now you are saying that state of Tamil Nadu is there. The year is also there, but Narayan Murthy is not there. Right. At that point of time, what happens is just to prove or just to make one case in your name and to prove your contention, we make a false case. So whenever a false case is being made, what happens is you will never find a case like you will never find something like any judgment for it. Okay. Related to the very same thing, why case law is important and why sometimes case law is also not important. Both aspects are there. And you have to actually tackle the very same thing in a very balanced manner. So I remember in 2015 or 16, I appeared for one national moot court competition in Amity Law School, Lucknow. Now, when I was appearing there, I actually found that there was the problem of the moot court was of sedition. Now, everyone knows this particular thing that if in Indian soil, if the flag of India is being lowered down and Pakistan's flag is being raised up and some slogans are being made, it was a sedition, it was a crime, right? So when you are defending that particular thing, I believe there was nothing to support. If you are against it, that yes, it is a sedition, you have a lot of things. But when you are in support of it, when you are about to say, it's fine, it's not a problem, like raising down Indian flag and lowering down Indian flag and raising up the Pakistan flag, it's not a problem. So moreover, it's very important at that point of time, what will you do? At that point of time, what I did was I was unable to cite any case law, and I was at a position of quarterfinals. I was unable to cite any case law, but my competition's timing was of 25 minutes of one team, was 25 minutes. And I know you won't believe, but my own session took 45 minutes, in which 35 minutes I spoke. Right. Now, even if you now ask me that, sir, what you actually spoke about, what was the thing that you had in your hand? There was only one thing. That is nothing more than a newspaper article. That's it. Now, in that newspaper article, there was one newspaper cutting being there, which was stating that if on the soil of Jammu and Kashmir, you raise down the flag of uh, India, uh, at that and raise up the flag of Pakistan, it's not sedition. That's it. Which was which was being explained by this person, one of the spokesperson of the government of the Jammu Kashmir government. At that point of time, this was the only thing which was there in my hand, and I have spoken up for like almost 45 minutes. The whole session took place for almost 45 minutes, and I was there for almost, I would believe, nearly 35 minutes across. So I have actually cited the very same thing in the compendium. Now, the moment the person, and you know what, I would really say, I have referred the same thing in compendium, but I have not referred the very same thing when I was speaking. Because I know you might be able to realize if I would have said that this is cited in one of the newspaper, you won't rely upon. And if you won't rely upon, why the judge will rely upon? Right? A senior professor was there as a judge there, and the arguments got very high. At that point of time, even the judge said, counsel, please relax, have a glass of water, and then simply conclude. Don't come to prayer also, conclude. Right? It went to that stage. So the reason why I quoted this example was it's very important for you to understand that whenever you cite any type of case law, you should first check it. Check it from AIR, check it from SCC or Manupatra, whether the case is original or not. And when you are able to find the case, please download the case. Once you download the case, then check the content that you are about to write. Right? It's very important. Because at that point of time, if you are able to cite something, but you are unable to quote it, right? You are unable to refer the same. It will be very much difficult for you to actually convince the bench. You won't be able to convince the bench. And I'm telling you, the bench is something that until unless they are 100% satisfied, 100% satisfied, they will never appreciate the fact that the contentions that you have raised up is valuable enough to give you marks, right? Secondly, that when we come upon relevant sections of statutes, moreover, it's a practice that these types of things are being mentioned in the memorial itself. So indifferently, like you don't have to refer it. But if you want to cite the very same thing, the same can be even be a part of your compendium, right? Next is in terms of any international moot court competitions, you are referring the treaties and convention. So how to even cite the treaties and convention, I'll just tell you in my further slide so that it will be very much efficient in a proper strategical manner. See, I am teaching you strategy in terms of making a navigation through the compendium. The very same thing, even if I don't follow, it won't be of any use, right? The very same thing, I will be even discussing it in the further instance. The last but not the least, that is the papers, various academic papers of various journals. See, now there is one very interesting part in this. Whenever we talk about papers, how will you identify that whether this paper is accepted by the court of law or not? Whether these papers, knowledge or the resources that has been given shall be accepted or not? Few things are there. But whenever we talk about any good journals, where first and the foremost thing we need to check that who has written the paper. On the basis of the same, if you think like that there is something valuable insights being given, valuable insights, always remember, it should not be a copy paste content. Because in India, research means take content from 10 places, reframe it, use pullbot, reframe it, paraphrase it, and the content is new, brand new content. You should not do it. You should actually avoid it. Those things you can definitely not refer it to the in moot court competitions or something, but this is the thing that you need to take care about, right? Coming up to the next part, which actually makes very important statement, how compendium can make you feel confident. See, compendium is not here acting as a key to success. It's not. Never. Don't believe that, please. Never. So what actually compendium helps you in? It actually helps you in getting that confidence from inside from you, which nonetheless, when you stand on the podium, when you spend of time, you need something with you. Okay, before I move forward, let me tell you one instance of quotes, real life quote, because there are people who might believe, or the students who might believe that, sir, in real life quote, these compendiums are of no use, or in real life quote, the compendiums are never being even referred. So, students, let me tell you, not only in court of lower court, high court, or supreme court, in every single court, whenever you are there to speak or to put some kind of reference upon any judgment, you have to give a copy of compendium to the judge. A copy of compendium to the judge. Trust me, one copy. And even you have to share the same thing to the other side also, so that they can also rely that yes, whatever you are referring has been there. Because let me tell you how I know. Because I have been there as a practicing advocate at Lucknow High Court from almost 2 years. And I have realized this thing because I have done the very same thing for my senior partner, where I've seen that not only on occasional basis, every single day, whatever cases we have, at least a compendium of 5 to 10 cases I used to make. I used to make because I was good in taking notes or making the relevant portion and then filing it as a compendium. I have done that. And you won't believe in one single day, if I'm not wrong, I might have gone through 50 to 60 judgments to curate a couple of compendium. Because, for example, in lower court, there is one case. In high court, there are 2 cases or 3 cases, and 3 cases in three different chambers or three different courtrooms. Every single morning, try to make the compendium and put it forward. So these are the very basic essentials that it not only helps you getting a confidence, but it also makes you understand that whatever research has been made at that point of time, it's valuable enough, much valuable enough, I would rather say. So the very first point is, if it's a matter of confidence, you actually have to curate the compendium in which all your legal authorities are there, the case laws, statutes, treaty, whatever was being governed, that what type of sources are there, you can actually refer it. Next is, it actually serves as a comprehensive reference for all relevant materials, all relevant materials. And see, one thing, if we talk about referring to any form of compendium, and if we talk about any form of like making a compendium in which all resources are there, if you are making compendium, every single document has to be the part of the compendium. Every single document. It should not be like only the case law is in the compendium. The other supporting judgments or any other supporting or new thing that you are coming up at that point of time, you are actually giving it by hand. That won't be done, right? So you have to actually take care about this thing, correct? So now, whenever we talk about the next part, which consistently and which is very important, that stakes of systematic framework. Now, whenever we talk about these places of getting a systematic approach, in this, some or the other way, we actually forget about one thing that discusses upon the strategy in which you want the judge to go through your memorial as well as go through your compendium systematically, or I could rather say respectively. It's very important in that sense. Right. So once this has been done, What actually happens is that when you are actually giving oral arguments in front of the judge, you have to quickly, like in this, quickly, you have to cite specific cases which is mentioned in the memorial as well as mentioned in the compendium. I'll tell you how to refer that also. And you have to practice it again, 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 again. Then only it will happen. Trust me, if like I am the speaker, I used to give at least 10 to 15 times oral revision in front of the mirror or in front of my fellow members of the moot court team. The reason is you have to be so fluent and so quick that you are able to cite every single thing in front of the judge. You should not be in a sorry position that, okay, I have lots of cases, but I missed. I was unable to speak. This should not happen. That's why quick, fast approach should be made. So what actually the judge looks forward. Moreover, the adjudicators often look forward for a quality of research. And see, let me tell you again, the concept of quality of research does not mean that you have hundreds of cases or 50, 60, 70 of cases. The quality of research actually stands out that in whatever thing you are citing in front of the judge, at that point of time, it should be so specific in nature that the judge is able to actually understand that the person has done a systematic research in a strategical manner. You might have been remembering about that I have used a word called as navigation. The word navigation means you have to navigate the judge or the adjudicator to go through your memorial in the way you want, not in the way the person wants. Because the reason why I said this thing, see, being a judge will always try to eradicate you from the thing that you are actually speaking. He'll confuse you. He'll tell you, no, come to this particular point. The reason you might have seen the judge says during a very heated conversation or argument, that says, no, counsel, come to this point, first clear me this point and then go to the next point. The reason is you have not satisfied the judge in terms of any particular judgment or any particular question of law. You have not done so. Narendra, if you don't mind, I'll take the question at the end. So you can lower your hand. Thank you so much. So whenever we talk about the quality of research, it's not only about that what type of cases you have referred. There is one instance again, and I've seen the people doing the same mistake. And trust me, I'm not demotivating you, but I'm telling you, you are doing this, you are in the right track. What people does is because the same thing I have also done, and I have recovered from it. That's why I'm saying that if you are doing the same after this session, we'll improve it. I can assure you. What happens is, whenever we start making a research, many a times, whenever we find something on Google or from any other sources, whether it's a case of 1950, 1942, 1932, or 2000 or back 2000, we copy paste. We'll not even bear to find out whether there is any single case law referring to what we are stating or what we are willing to speak. Is there anything on that or not? We barely care. And trust me, it's casual, it's normal. It's nothing like that, oh, Jyotirma said, didn't do it. I am doing, why, what? It's okay, relax. Nothing to worry about. After this session, you must assure this thing, that whenever we talk about quality of research, it means as recent the case can be, yes, irrespective of landmark judgments, but even in landmark judgments, there is some or the other alteration in terms of the major instances to that particular case comes and we barely consider it. We don't consider it, and it's okay. We don't consider it because it's normal. We don't do it. But please, everyone, whosoever is listening to me today from this particular great initiative, you should assure yourself that from now onwards, you will avoid it. Asta, if you can please switch off your video and mic. We are able to hear music. Okay, thank you. So at this particular instance, I believe you are able to understand that how compendiums actually makes you feel confident whenever you are standing in front of the judge. Moreover, that's something which is very important to understand. Like, so next, which comes is how to compile a compendium, right? I will be coming to the next slide, which will actually help you out to understand few major things upon the starting of the compendium, the purpose, and every single nuances related to compendium. I must assure you completely that through this platform, you will be able to make a good compendium in your next moot court competition. And if you do, please thank RSLW for the same, because without them, I don't know whether you won't be able to reach me, or I won't be able to give you this kind of advice in any other portal until unless you know me. But this initiative will be making you successful, and I can assure you that. So coming up to the compilation, see the very first point. If you are able to see, please read it. If you want, I can share you the whole PPT. It's very much will be benefiting you. The first point says that strategically arrange all cases within your compendium to align up with the framed issues and arguments at once. The reason why I have stated this thing, that whatever cases you draft, please draft it according to the issues that you have framed. For example, if you have stated issue 1, 2, 3, and 4, the all the cases has to be in a systematic order, 1, 2, 3, and 4. It should not be in the format of like ascending order or descending order in terms of ABCD. Don't do it. In index, it looks good whenever you are submitting any type of thesis or PhD or anything like that. Then it looks good. Just if it is there just to showcase that what type of cases or what all cases we have cited. Not more than that. Right. So in compendium, moreover, you need to take care about this thing, that whenever you talk about any this type of practice, it is very important that we actually make the whole system or the whole approach in such a manner that the person who is going through this should be actually able to understand that how the whole conceptual memorial is to be taken care of. Because if we are not doing the same, it's very casual for anyone to go through it like a bare, like a book or the notes that is there in front of. Nothing more than that. And I truly believe this thing, that if you are doing something like that, it won't be of any help. Correct. So try to figure it out that whenever we talk about making a compendium, I know it takes a lot of efforts, it takes a lot of pain, but it will be surely worth it. I can assure you that. And you don't have a choice. If you are going for a moot, you don't have a choice, and you have to like bear with it. Like, so try to bear with that, right? So coming up to the next point, which speaks about that a very well structured arrangement, like the whole concept that I explained you, will actually benefit or facilitate you in terms of streamlining the whole thing that you are about to prove. You have not proved it till now. You are about to prove. And ensuring that judge can easily navigate the document. See, whenever we talk about making the judge on a free position, it simply means you are actually helping the judge, that if your lordship may please refer to page number 3 of the compendium, the judge will simply turn and he will see, okay, in page number 2, this is a cover, and in page number 3, the relevant portion is in marked. Which proves, and then you have to say, which proves the basic essentialities of my issue number 1, which clarifies the point of a discrimination being stated in the first issue. If your lordship may please refer to footnote number 3 or footnote number 13 in the memorial. In the case of this, alongside, refer to page number 72 or page number 14 of the compendium. In the case of this particular case, the Honorable Court observed this. See, when I'll tell you a few more pointers, trust me, it's very fascinating. It actually it feels good. Because see, the person who is a judge, he wants you to greet him with utmost humbleness. Whenever I take like the recently of PGCL Mumbai's one of the competition where I actually briefed the judges previously. I actually said that try to witness that whether the students who are acting as a counsel, are they helping you to navigate through their compendium or not? Because memorial everyone does. It's no new. It's normal. But whether the student is actually taking you through the compendium or not, and trust me, I believe, according to my knowledge and my experience, 70% don't. It's there in front of the judge, like a beautiful showcase, a beautiful frame. That's it. So what is the use? Why you have spent money? Why you have spent a lot of hard work on it? Then at the end of the day, it's of no use. Correct? That's the point. Now, the third pointer, which is very much important, which says that construct your compendium in a manner that guides the judge through the document in synchronizing with the arguments that you have presented. The reason the above and this point is almost similar, which says that your argument should be in such a manner, whatever cases you have cited one by one, the whole judgment should be put in up one by one. It should be not in a position that you are citing some different case and the case is being referred something different because it's not in a synchronized manner with what you are actually referring it. Right? So this has been done. The next pointer which comes is that for an even more structured approach, like this is a practice that in the past few years I have actually evolved, that I have seen people that even in terms of making the High Court judgments or Supreme Court judgments in reference to the MOOT problem. Please, if for example, if it's a matter of High Court, don't try to quote a lot of High Court case. If you don't have, it's okay. Now, there might be something that you might feel that, sir, firstly, you are saying that the whole this particular compendium should be in a synchronizing manner, but somehow or the other way, the Supreme Court cases is referred on page number 5, but the High Court cases are referred in page number 2. What to do? In that point of time also, I would rather say in index, write Supreme Court cases at the top, then the number of cases, then the High Court cases, and then the number of cases. And you refer differently inside the compendium, so that the synchronization that you have followed in your arguments, the very same thing is actually followed in terms of the compendium, not in terms of the index. Keep that thing in mind. I'm not talking about the index. I'm talking about the content of the compendium, the series in which the cases needs to be recorded. Understood? I believe you might be understanding the very same thing. If not, we'll discuss it at the end. I'll give you 5 minutes, 5 to 10 minutes. You can discuss me the nuances accordingly. So once this is done, another which is very important, like I must share one of the instances of mine, of my very first MOOT where I went to RJNUL Patiala. It was, I think, in back 2015, I guess. So in that MOOT court competition, I was not aware about what compendium is. And you might feel very funny because what mistake I did costed me across 2,000, 3,000 rupees in printing. If you are able to like imagine what I have done, I must share. I got to know from said that finally we'll be now drafting the compendium, what to do, what not to do. We got to know that we have to print pages, a lot of pages, because we got to know that we saw that there are cases like 50 page, 60 page, 70 page, 80 page, 100 pages are there. And we were like, Are Bapre, how we can print 100 pages of case on judgments just to cite in front of the judge. And can you imagine that in my first MOOT court competition, we went to semi-finals, we lost there. But when we went there, I think our clothes bag was of almost like one bag for clothing and everything. And I think 3 bags were there for compendium. 3 trolley, I'm telling you, 3 trolleys were there for compendium. This huge, if you are able to, this huge size of compendiums, spiral bind. And like it took almost 7 days for printing and spiral binding. But at the end, it was been done. So I know what happened was I truly imagine at that point of time, we might have referred in one particular case, one paragraph, not more than that. And we have highlighted the same thing. So once we have referred, we have we used to put the whole compendium, and I can't say that. For example, this is the height. Now almost thrice was of bundles. Like the picture that is being shown, it is very less than what we have printed. I can tell you this. This I think double the picture of this we have printed, double the pictures of. And once we have put up in front of the semi-final bench, they actually said in the open court only that council, it seems like that you have printed the whole judgment. And we were like in a position that yes, the same thing has been done. From that day, I got to understand that it's not like that you have to refer the whole thing. A certain things you have to refer. What will be the certain things? I'll tell you in the next slide. Okay. So next is the factors before making compendium, where the first thing comes is the cover page. Right. So if you are able to see that we are having one blue and one red. So red is basically for respondent, R stands for respondent. And the other hand, we are having petitioner or the appellant. So petitioner or appellant, it will be blue. Moreover, this blue is actually being referred by everyone. So this is the thing that is there in front of you also that you need to take care about. Where the first thing is, we actually call this as a cover page, right? So cover page consists of like, if it's a petitioner, it's blue and respondent, it's red. So it basically must contain from which side the compendium is. I forgot to write the side. So please ignore the thing. So it basically needs to say that from which side the compendium is all about. Right? So if you can zoom it on your screens, you will be able to see that what all things are there. Next is the name of the moot court competition. You will write on the top. Then you have to write the team code at the top right corner. Until unless there is some other advice being given by the moot court competition organizers, it's most probably in the top right corner. You have to mention team code or TC, short form of it, and you have to mention the code that has been there. Please assure that you should never mention your institution, university, or individual name. It's the disclosure of your identity, which will like terminate you or suspend you or remove you from the competition. So kindly assure that. Next is that how to prepare a first page of the compendium. And see, the first page and the cover page is completely same. No differences there. Until unless you only want to write the name of the party and compendium from the side of petitioner or respondent. It's the same thing. So the first thing is team code at the top right corner. In the center, you can write the name of the competition. Then you can write the name of both the parties. Now, it's your choice whether you want to write the name of the party in a single line or in a first you can write the name of the first party, that is appellant or petitioner. Then you can dot, and then you can write petitioner or appellant. Then in the next line, you can say versus, and then the name of the respondent party, and then the respondent. Then making two spaces, you can simply write that compendium of petitioner or respondent, it's your choice. And then at the end, we usually write counsels on behalf of petitioner or respondent. Understood? I think it's very simple. I will send it to you all so you can refer it for your next competition. Okay, this is something important, very important. I know all the above slides were also important, but this is more important. I could rather say in terms of my academic ideologies and everything. If you are able to see that what this is all about, let me zoom a bit so that you can view it properly. I believe you are able to see. So basically, this is the index where the serial number has been given, the name of the case, and page number, right? So page number, you have to fill it manually because as this is the printed cases, so you cannot number it, right? So physically, you have to number the same. Now see, I have done two things. First is issue number 1. Then I have mentioned Supreme Court cases, 1, 2, 3, 4, 5 pointers, High Court cases, 1, 2, 3, 4, 5 pointers. This is something that I do. If you want to do something else, you are free to do. Everyone has their own style of mentioning or covering, or I could say quoting the things. So you are completely free with that. No problem in that. So the same thing, see, issue number 1, issue number 2, and issue number 3 has been done, right? So coming up to the major thing, that basically the index page bifurcates, I believe. See, I would only tell you something which is practiced in the court of law, especially in terms of what is there in the market, so that whenever you stand in front of the judge, you should never feel like, and you can remember me, what Jyotirmoy sir said, or what RSLW's workshop had, and how I could benefit from it. This is the like a basic thing, right? So at this point of time, just a bit. At this point of time, it is very important to understand that bifurcating your cases by simply mentioning Supreme Court or High Court cases will actually reduce a lot of pain from you. The reason why I'm speaking about the pain from you is many a times it's impossible to identify which particular court the case is all about, because you have already printed it. Either it will, you have to go through the compendium completely, and then you will be able to find out whether it's a Supreme Court case or a High Court case, until unless you know it if you are referring it, because you might have hundreds of cases, right? But from hundreds of cases, you will be only referring to like 5 cases or something, right? So this is something that you can take care. If you feel my suggestions valuable, surely you are free to do so. Next is formulating a proper structure by separating these 2 cases in reference to the year of judgment passed by the court. This is again another thing. See, various categories can be there in terms of formulating how you are willing to prove the bench that the quality of research that you have done is amazing or out of the box. Because the same process is being followed by many. What is the difference that you are doing, right? If the same thing is to be cited by every single person, what unique you are doing? So rather than me believing just to lecture you out that how an index page has been made or how a case is being referred, I thought about making a structure, and I have just quoted the very same thing. And I am telling you, this is the very same practice that I have done in the BCI competition, and it was very good. I went to semifinals and it was really good for me. Next is that formulating the precedents in accordance with each issue, which will help the judge to go through your compendium. And see, in the whole session, again and again, I am saying and deliberately saying and focusing upon one single thing. The only thing for you is to convince the bench that is sitting in front of you, never skip the question until and unless you know even a single point of that question. Until and unless you know a single point of that question. If you know even a single point, please try to elaborate it. Try to convince it with some case. And see, there is one beautiful strategy that I even practiced before. If you don't know the explanation and you have some case with you, because see, some or the other way, you be in a position to have the cases. So once you have the case, you are telling or like sharing the case in front of the bench. And if by the God's grace, the judge is able to correlate the same thing and he's been convinced, your job is done. That's all about everything like that. At that point of time, it's very easy because one case, your issue is being solved. Because on a primary level, many a times you don't have that much time to support your arguments. You're making an argument or you're writing an argument of like 40 to 50 pages or 30, 35 pages. Are you able to speak all that you have written? No, you cannot write. So what you need to do is you actually need to focus upon couple of major cases that the moment you speak and you collaborate your issues along with the arguments, at that point of time, your concern is over. The very same thing has been done in terms of helping the compendium, helping like a support system in terms of the compendium. So now see the mistake that I did and then I recovered from it. So this is one of the case in front of you where I've written the title as how to prepare a case in compendium. Now, for example, you are having a case of like hundreds of pages. And I know practically it's not like practically possible to print the whole thing. So what we do is three things. Or sorry, two things. First is the first page. If you are able to see this first page, this is a first page being downloaded from Manupatra, and this is not of Indian Canon. So, and I would also request you, for reference, you can check on Indian Canon, and for reference, when you are able to, when you are actually going to refer the same thing in Compendium, please and please only from Manupatra, SCC Online, EBC, AIR, or any other like suggested or recommended platform. You should not take the like these types of things from any other local platforms, like because there is a rumor that in Indian Kanun these cases content can be changed. So if these can be changed, then definitely it's of no use, and sometime or the other way the panel doesn't. And even I have seen while judging the event, I have seen this thing, people used to refer because some or the other way you don't have a choice. So if you don't have a choice, then it's something different. But in that case also, there is one more amazing thing. Yes, but for that, you must be aware about that how to trace that particular case from the Supreme Court judgment, Supreme Court's website, or any other High Court's website. The best is, if you want to find a case, go on Google, type what you want, and if you are able to find a case, just check what is the date of that case. For example, if it's 26th May 2019, and now you want the case of proper source, you don't have Manupatra, you don't have EBC, and this particular case is of Supreme Court. What you will do is please go to Supreme on Google and write Supreme Court judgment. The first link will come, you just click it. The moment you are there are various ways by which you can download the case. There are case diary, there are like what type of case it is, whether it's a writ petition, whether it's a criminal revision, whether it's a SLP, anything. Then there is dates, or there is the name of the judge, right? Or there is some or the other way order number. These things are there. So most probably the most efficient way I believe is the date. So you just click on the date. There are two instances where you have to write the first date. For example, if it's 26 July, you don't need to search multiple cases. In both the spaces, you can write 26 July 2019, 26 July 2019. There is a captcha that you need to be filling it. Just fill the captcha, enter. The moment you will enter on 26 July 2019, whatever cases has been decided by the Honorable Supreme Court of India, all the cases will be there. Now, on the right-hand side, there will be a column in which the download option has been there, or view option might be there. I don't remember actually. These two options, one will be there. You can simply click it. Supreme Court judgment is there. The very same thing is for all the respective high courts also. At that point of time, it will be very much feasible for you to go through it, right? So the first page is of the main case, the first page of any case. This you have to print, first thing. Then you have to print the referred page. I must zoom it out for you guys so that you will be able to see. If you are able to see this thing, wait, yeah. If you are able to see this thing, see this particular thing is there, and of this particular case, this Balco Employees Union versus Union of India, I am referring this particular paragraph. So see, I have beautifully made highlighted the same. And you can highlight the same in your Word file itself, like for example, PDF document itself, and then print it. So automatically it will be a black and white portion. So it will be easy for you. So see, this is the first page. Wait, this is the first page. If you are able to see, this is first page. This is 1. Then comes the referred page. This is 7. And another portion I have taken from page number 17. And the portion has been highlighted. So when you are going to print, you have to print all these all these 3 pages. That's it. So in the when you download the PDF where the name has been written, you can write 1, 7, 17. Once you give it to the printing person, you can say that whatever number has been given, please print all these 3 and staple it. So what they do is they arrange it this format, and you are having a case. These 3 documents are a part of your compendium. You don't have to take a printout of 50 pages. Understood? This is the thing. This is the efficient thing. If I believe if I would have known in my times, lots of money would have been saved, but this was destiny. Once this has been done, what happens is, see, some type of explanation has been given that please, there is one thing sometimes when you download from SEC Online or any other sources, the name of the college has been mentioned, or sometimes the name, your name has been mentioned. Please don't do it. Never do it. Because if you are able to find, if the judge is able to find, sometimes they bar you. Like if I like I remember one of the instance when I was there in GGSIPU's competition, and I was there as a judge, and I found that the name of the part. So I was a like good-hearted judge, so I have not barred them, but my fellow colleague was actually asking me to bar them or make them like out of this competition. But it was a minor point, and rather than knowing, it barely would have helped me because I was unaware about the students. So it like majorly didn't help the students also. So you should actually try to avoid. Don't take that risk whether the judge is of good heart or not. Don't try to go with that. Next is it's being written that must highlight the referred areas of the judgment. Then I have written the same thing, two major essentials. First page of the judgment, referred page of the judgment. Both the things you can write. Yes, now there is one basic dispute sometimes, that is whether the compendium must be of spiral binding or stapled or that thread-like structured. See, in India, as we have hundreds of, not hundred, thousands of colleges, thousands of people, and thousands of ideologies. So we cannot restrict them accordingly. So at that point of time, what we actually need to do is, moreover, spiral binding is something that makes the process easy. That's why it's being recommended. And you might have seen that sometimes the organizer itself, in their whole book list, they refer the same thing. So once this is done, you can decide, see, mutually, you can decide among yourself. The more professional you will be, I know in spiral binding, some money will be going, kharcha hoga thoda usme, but moreover, it will be professional. See, you should not look the compendium, the formation of the compendium, like you yourself are going to judge. Don't do that. You have to think from that perspective that the person who is sitting as a judge, he's a real judge. He's not a student like me who will like, okay, it's okay. The person has used a thread to bind up all the things and he has given. So it's basically professionalism. There are people who actually refer the whole thing in a proper file, case file, or sometimes they use a brown file also. I don't, okay, I have this brown file also. I'll just show you. So for example, this is the brown file. So what they do is inside that, they most probably, sometimes, some or the other way, they actually refer it and they do stitching. See, this stitching process comes into action when you have a bulk compendium, right? So this is something that you can take care about. Now, see, one important segment is there before I think few minutes I'll take and then I'll try to end up the same. That is how to refer compendium during oral rounds. See, when I'll send you this document, it's very important for you also that, see, I've written few things. That is, if your lordship or ladyship will be actually going through one thing that in the very beginning, when you say or plead before the bench, if the honorable bench may please, if the honorable bench may be pleased, the council seeks permission to address the bench collectively as a lordship. So, for example, if there are two male judge and one female judge, so you can try that if the honorable bench may permit, council seeks permission to address the bench collectively as your lordship. So if they all are satisfied, which like 95, 99% they agree on it, then you will say lordship. For example, if there are two female judges, you can say council seeks permission to address the bench collectively as your ladyship. So to both the ladies or judges, you can refer them as ladyship. Until unless it's a lower court case or a consumer dispute case or any other judge who believes and wants that you should not call us as lordship or ladyship, they want you to call us as your honor. You can call them your honor. But the practice is what is going on. I'm telling you the same thing. The different things can happen in different competitions. So you have to adjust accordingly. So moreover, what I used to practice is that, and there is 5 different ways in which these things can be referred. For example, if you are speaking one of the cases, you are quoting something. You can simply refer that if your lordship may kindly turn to page number this, or what I speak is, if your lordship may please refer to footnote number 13 in page number 14 of the memorial, alongside page number 13 of the compendium in the case of Narayan Trimurti and others versus Union of India and others. It was been stated, it was been observed by the Honorable Court that you spoke. So what happens is, and please, whenever you speak, let me just help you out with the body language. It's very important. Whenever you speak and whenever you refer that, if your lordship, please do it like that. You are actually respecting. You should not be in a position like this and you are speaking. Right? Don't make yourself at a rigid position. It's very unprofessional at that point of time because you are acting as a real lawyer there. So you have to actually speak. If your lordship may please refer to footnote number 13 in page number 42 of the memorial, alongside page number 13 of the compendium. When you are saying alongside page number 13 of the compendium, please observe that whether the judge is going through your compendium or not. You can observe for 2 to 3 seconds. You can just make a gesture so that they can also put your compendium in front of you and they can turn it up. The very same way, there are multiple options being raised up, like in the case of this Narayan Murthy and A, which is being cited in footnote number 34. Page number 19, alongside page number 3 of the compendium, your lordship, the Honorable Court observed in this case as this particular thing. So these are the various instances, the various aspects, or I mentioned, or I could say referred. Right. So this is your choice. 5 things are there. If any other thing also comes, you are free to do. But always remember one thing. I know these lines are very long, so you have to be quick, very quick. You cannot be very lazy. If your lordship may please refer to page number this, page number 2, almost 1 minute you are losing it. And in 1 minute, you can actually make one contention, right? So these things you have to actually think about. Other than that, the only thing that you have to practice is that try making a cross-referencing method. You are seeing whatever, I don't remember, I don't know what you have attended in the previous sessions, but I would rather say one thing which actually helped me a lot in my moot court competition. That is, please make 1-page note. If you are good in making notes, first issue, 2 point, 2 cases, which page number, which footnote number, and which page number in compendium, everything in 1 line. So whenever you speak, you are able to see every single thing in 1 line. And what you have to speak, make in 2 lines. That's it. This is 1 note. So this will be here and the memorial will be here. You don't need to have the compendium. If you want to have the compendium will be with the team. They can refer it to you when needed, but you should try that. You should not go through the compendium because everything is written in your 1-page note. Right? So everything will be there. If you are making compendium, you have to refer it. You must refer it. It's compulsory for you. Don't be in a position of laziness that if I will be going through it, the judge will ask me tens of questions or hundreds of questions. And now you have made it, now you have to face it, and it's obvious. And because you are there to win the moot and you are making the compendium, so it's obvious enough. So making the presentation of the compendium so appealing that the bench can realize about the hard work or the effort or the quality of research that you have done. And trust me, when I have seen this, I have given marks. I awarded marks. Because the awarding of the marks only bases upon a couple of things, because what you are speaking, the very same thing is being spoken by other people also. What's the difference? The difference is quality of research, the strategy or the system that is in practice. So I'm just coming to, I hope I am already been there on my last slide. So thank you so much for being such a great audience. And there is one thing that I've written for you, for everyone, that is, always remember that the perfection is a task and will never come in a day. And the reason why I'm stating this because I am one of those persons only. And the more you polish your skills, the more efficient you will be by the end of your task, not goal. Goal is different. Task is your moot court competition. And this particular statement, don't think, just believe it. Okay. So with this, I will be ending my speech so that I will be opening up with the questions or something. Over to you, Dikshita.
Thank you, sir, for such an informative session. This will definitely help our participants. Note to all the participants, kindly keep your cameras on for a group screenshot, and I request you all to fill the feedback form. Now, I would like to call upon Ms. Tanya Agarwal ma'am for vote of thanks.
Ma'am, please unmute.
Thank you, Dikshita. Good afternoon. I feel so honored to have been asked to deliver this vote of thanks for the 4th session of RSLW's 2nd National MOOT Code Training Workshop on the topic Formulation of Compendium. I, Tanya Agarwal, on behalf of Rajasthan School of Law for Women, would like to extend a very heartfelt gratitude to our resource person, Mr. Jyotirmoy Banerjee, who very eloquently and articulately explained the topic. Thank you, sir. Compendium is a compilation of legal and other authorities that the team seeks to rely on. A compendium is used to verify the credibility of authorities cited. Sir stressed that the process of crafting of compendium starts from the very beginning of the preparation of the MOOT Code competition. A good memorandum provides a point of confidence to the team in their research. Sir very rightly stated that it takes the whole team to craft a compendium. We thank you for such knowledge, sir. I express a very sincere thanks to our principal, Dr. Vardhika Arora, for her generous encouragement and guidance in making this event possible. Thank you, ma'am. An event of this magnitude cannot be organized single-handedly. It requires a dedicated team to accomplish the task, and we are very lucky to have this. We recognize the unwavering efforts of the co-convener, Dr. Disha Bangarwa, and organizing secretaries, Ms. Palak Vashisht and Ms. Khanjan Sharma, to make this event possible. Thank you, ma'am. The untiring and zealous efforts of the organizing committee and the volunteers should not go unnoticed. They have acted as the backbone for making this event come to life. Thank you so much. I thank all the faculty members and the non-teaching staff for their enormous cooperation. Finally, I'm immensely thankful to all the participants from various law colleges of India for their involvement and inquisitiveness, which has made this event a great success. Thank you so much. I hope this session has shed more light on the topic of formulation of compendium and the intricacies involved in the process, which will help you in MOOT competitions that you take part in the future. Thank you for your cooperation. Thank you. Thank you, ma'am. And thank you all for attending today's session. See you all in tomorrow's session at 10 a.m. Thank you.
Thank you, Tanya ma'am. Thank you, Dikshita. Thank you, Jyotirmoy. It was wonderful having you.
Thank you so much, ma'am. Thank you.
And that thanks go to Disha ma'am as well.
Really. Thank you, ma'am.